Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item number 34.
Number?
34, Lordship. Taken consent from the parties.
No objection, Your Lordship.
1 week, Lordship.
I'm for the state responding.
1 week, yes.
Much obliged.
Highly obliged.
1 week.
May I please, Your Lordship? Your Lordship, I beg to mention item number 20 and 21. Your Lordship. I pray-
20?
20 and 21, Your Lordship, connected. I pray the matter will be taken up after 2 weeks, Your Lordship.
Why 21 matter? 2021.
Yes.
Your Lordship, 20, my Lord, is given as second appeal. But if Your Lordship will go to the cause title, it's actually an application under Order 6 of the Assam High Court jurisdiction. That has to be corrected. Although it's listed as a second appeal,
That's not a second appeal.
no, because the cause title will show
Yes.
that's under.
You can convert it.
In fact, it was converted. Initially, when the appeal was filed, the revision was filed, the first order would show that it was converted into a second appeal.
But it never reflected.
No. Because, my Lord, if they come under now Order 4 or Order 2, now the question of court fee will come into play. Because an appeal would lie only if the suit is valued over a lakh of rupees. But this suit is valued at 30,000.
You heard that?
Your Lordship, I have no idea, Your Lordship.
You have no idea.
That has
That's
to be
very
corrected.
fair, yes.
Has to be corrected.
This after it will call out today or what to do?
After 2 weeks, Your Lordship.
It's up to them. Because it's there.
It's your appeal, yes. After 2 weeks, okay.
All right.
May it please Your Lordship, I'd like to make a mention of Item 32. This matter can come up after 2 weeks.
On behalf of Mr. R. Guru,
Yes, Your Lordship.
I'm for the state, Your Lordship.
no objection.
No objection, Your Lordship.
1 week, yes.
Obliged, Your Lordship.
Obliged, Lordship.
May it please Your Lordship, I beg to mention item number 25. Your Lordship, the conducting counsel, Mr. K.C. Gautam, is unwell. So I pray Your Lordship that the matter may come up after 2 weeks.
I'm for the
Okay, that's our counsel will unwell after 2 weeks, yes. Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 30 on behalf of Mr. A. Khan, Your Lordship, for the state.
30
30, Your Lordship.
on behalf of Mr.
A. Khan. He's on sanctioned leave, Your Lordship.
No objection, Your Lordship.
Okay, 2 weeks, yes.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 33, Lordship. Due to personal difficulties, Lordship. After 2 weeks,
Yes,
Lordship.
where's Mr. P.T. Sangma?
Stand.
Why don't you do it? Okay, 2 weeks, yes.
Highly obliged.
What?
Please, Lordship. Lordship, I beg to mention item number 22, Lordship.
My lord, regarding with this, the question of settlement is not arised.
22,
My lord.
memory link door.
Lordship, we've called the parties yesterday, Lordship. It seems like discussions is going on, Lordship, for settlement.
There's nothing such, my lord. Let the matter be called out or have something to say, my lord.
Let me hear objection, let me call out this. You be here.
daily list item number 1.
Where's the rejoinder file?
Lordship, the rejoinder is not ready, Lordship. I'm
Why?
praying for some more accommodation, Lordship.
How many times you saw it?
Lordship, this is the second time, Lordship.
Rejoinder
Because,
is not
Lordship,
a matter of
earlier
right.
they have filed their
Anyway, further
2 weeks
of
time,
1 week,
Lordship.
as per allowed for rejoinder.
Deeply obliged, Lordship. 2 weeks.
Item number 2.
Affidavit from the part of the union is not filed yet, Lordship.
Already filed.
I'll be filing it.
You're for? You will be filing.
Respondent number 6, performer.
You're for this district council?
No, my lord, for the same of Mara.
Okay,
State, Your Lordship, already filed.
How many times you prayed? When was this filed? 8 weeks time for affidavit in 25/4. When can you file? Instructions are received. Yes, MS Iprasan submits that the as 13 sent for signatures. This after 2 weeks.
Item number 3.
Your Lordship, I pray for 2 weeks' time to file an affidavit.
23 matter. Now we are in July.
We haven't got instruction, my Lord.
You're for the government.
Yes, my Lord.
You haven't got instructions since last year.
They actually, on the last occasion, the petitioner informed that that they have filed a representation is pending. So
File?
representation is pending. So
No. I mean, you have not. What's this matter about?
This is pertain to promotion, Your Lordship.
promotion of
Which
The
department?
senior school service.
education,
This is?
Education department.
education department.
You mean to say that since this matter was filed in 2023, you have not got instructions till now?
We haven't got instruction. Actually, this case is handled by A.H. Karwalang, and he's
I
not
think we
well.
will call the officer concerned if this is the attitude that, they're not being alive to the case in the court. Who's the
2 weeks
concerned
time, no, no.
officer?
Lordship, I'm appearing on behalf of responding 6 to 10 and 13 to 15. Lordship.
6 to 10? You already filed affidavit. You already filed. You won't be filing. This matter, which has been filed since Mr. A. Moment, learned counsel for the learned government counsel appearing for the state respondents, submits that till date no instructions have yet been received from the official respondents. It is stopped. It is noted the matter has been filed since December of last year, and therefore it is strange that the state respondents are not responding to such a petition. Expected by the next date that the affidavit of such will be on board, filling which other orders will follow. Yes, Amit A. Pradhan for so and so. Raise funds also allowed 2 weeks time for affidavit, less over 2 weeks. This can't be the attitude that that
Item number
7
4.
months the matter is pending and not bothered, even instruction not received also.
Item number 4.
Wait, please, Your Lordship. Your Lordship, I'm entering appearance today on behalf of the respondent. Your Lordship, we've not received a copy of the contempt petition.
I've already served, Your Lordship.
To whom?
To the concerned respondent. Yes, Your
You
Lordship.
give
Okay, Your Lordship.
MS Zainab entered appearance today on behalf of the sole respondent. And please, how much time for affidavit?
2 weeks time, Your Lordship.
Please, time for affidavit. First submits that 2 weeks time for affidavit. Next, as it has been stated that he is not in receipt of the petition. Petitioner directed to supply a copy of the same within the course of ready.
Obliged, Your Lordship.
Just after 2 weeks, yes.
Item number 5.
Lordship, we have filed our rejoinder. The matter may be posted for hearing.
The parties submit that things are complete. It's the matter for hearing on so and so.
6.
May I please, Your Lordship?
Yes.
Your Lordship,
You want to file affidavit.
we will be filing, Your Lordship. We just received the instruction, Your Lordship.
What about this number 4? None appears. It's been served, correct? Office order 25/6/2024 has been noted that an affidavit indicating service upon someone has been filed. Stop. However, today also no appearance has been made on behalf. Are you sure you served respondent before? On behalf of respondent number.
I have served them.
Who's number 4? On respondent number 4. Stop next thing. Ms. Andraji prays for
2 weeks' time, Your
2
Lordship.
weeks. Submits that. Just Ms. Andraji submits that she has just received. They have just received instructions, and they may be allowed 2 weeks' time to file affidavit. Stop. Prayers allowed. So with regards to number 4, if no appearance has been next date, the matter shall proceed ex parte against said respondent.
Much obliged, Lordship.
Item
Yes,
7.
accordingly also.
7.
I'm praying for further 2 weeks' time.
Fresh, that's not a fresh matter.
It's a fresh matter.
As paid for a 2 weeks' time, that the response file affidavit is. Because thereafter and so on. So.
Item number 8.
I'm praying for some more time for affidavit.
Why was the matter about?
Promotion, Lordship.
Okay. Promotion?
Promotion.
So 2 weeks for the time has prayed.
3 weeks.
3
The
weeks
affidavit is
time has
confirmed.
prayed. Yes, to the response file affidavit. Yes, pension matter, time be shorter, yes.
9.
When's retiring?
Still time, 5 years. 89 a connected matter, Lordship.
9 also, same one.
Item number 10.
Most obliged, Lordship.
Lordship, I am praying for some accommodation on behalf of Mr. M.L. Nongpyo. Due to some personal difficulty, he could not appear before this.
Regarding a market matter?
Lordship, I got the papers, everything. I'll need some time to understand the issue.
It's very simple, Mr. Kanta. The thing is that they should go for the executive member in such markets. It's a matter regarding the settlement of market.
If they are in agreement, then no issue.
Council is not here. Yes, Mr.
Lordship, I am praying for extension of interim orders.
Yes, Mr. Vijikanta, Special Counsel, KHDC, submits that he may be allowed how much time? Maybe allowed how much time?
It's okay, Your Lordship. Let's give them 2-3 days,
yes,
and we'll close it.
Yes, mentioned to me on behalf of the arguing counsel, who still be indisposed today. So I can list this matter after 1 week.
1 week.
Yes, interim order to continue next day.
Highly obliged, Lordship.
Otherwise, this matter, it's 4-line order. I'll go back. Why have they come here?
Okay.
Yes.
Much obliged.
11.
Next.
Please, Your Lordship, I'm supposed to file an implement application, if you could remember, 1 week ago. So today it's not ready. I just need 1 more week time.
Yes,
just a signature.
For the 1 week's time is allowed to the petitioner file. Last time, Mr. Molong, why you fled away from the court on the matter of Supreme Court again?
I misconstrued what you said, Malord. I thought you said to some other parties.
Ah.
Sorry.
Misconstrued and misconstructed, it's like that.
12.
Yes. Yes.
Lordship will be filing our affidavit of service with regards to respondent
Filing
5 and 6. Affidavit of service.
On respondents number?
5 and 6, Lordship.
4 to 6. 4 to 6 or 5 and 6?
5 and 6, Lordship.
What about number 4?
4 as well, Lordship.
Number 4 is the council?
No, sir. 1, 2, 3, Lordship.
4 is Stephenson Lalu. The other 5 and 6 are performer respondents. You're not going to obtain serious service on number 4?
4 to 6, sir. 4, 5, 6.
Yes, MS.I. Kongman, letter counsel with the petitioner, submits that or going to file service affidavit.
Yes, Lordship.
To make it once time to file service affidavit indicating factum of service notice upon respondents 4 to 6. According to this, you're filing affidavit? No.
No.
List after 2 weeks, yes.
Small issue.
Hearing. Item 13.
Yes, Mr. Jindal, this will take long time. Mr. There's objection, some adjournment. Let's take up the matter. Small, what item was that? Item number 22 or something.
22.
Which item was it? 22? Yes.
22.
Because this next item is going to take the better part of the day. So, yes.
Yeah, here's my lord. He filed this.
1 second, 1 second. Let's get the file. Yes. Yes.
Yes, my lord. He filed this writ petition in two things, my lord. One is regarding with the civil dispute, and another thing is regarding with the development activities. So here, my lord, regarding with the civil dispute, the title suit is still remaining before the civil court. So another thing is the development activities, my lord. We are not dispute regarding with the development. Here also we can show in my affidavit in para 7, my lord, that we are not dispute. Even
no. The thing is that you said you wanted to make some submissions.
Yes, that is the thing, my lord.
What are developments?
Yes, regarding with the PMGS, all these road connectivities, electricity, water, electricity, we have no dispute regarding with that.
No objection, you mean?
No objection. And even in the rejoinder also, my lord, they don't have any objection regarding with that. So the remaining issue is regarding with the title suit which is pending before the civil court, my lord.
So there's no point in making this thing pending?
Yes.
We take instructions.
I'll take instructions. Because, Lordship, the instructions we got from our parties was that discussion for settlement is going on.
What? You're the Darbar?
No. We are the other things, my lord. We are
not Darbar, private individuals.
Private individuals.
Private individuals.
Because we have filed the claim as well in the civil matter.
In the civil suit.
Yes.
Doesn't matter. The thing is that now, is there any talks of settlement going on or not?
See, my lord, that kind of a settlement never is. Because we are...
And you'll not settle also?
No, my lord. Because we are still fighting in the civil court.
Yes. Though mention has been... adjournment has been sought on behalf of the petitioners on the ground that talks of settlement are going on. Stop. However, Mr. Kharshiying, for the respondents number
9
to
9, 10, 11, 12, 13, 16, 17 and 18.
Give the numbers on behalf of respondents number
9 to 19.
Except 14, my lord. 14 and 15.
Number 9 to 13 and 16 to 18.
16 to 18, my lord.
Yes. Submits that there are no such talk of settlement, and in fact settlement is not possible. Stop. Next part. Accordingly, learn counsel for the to obtain appropriate instructions. Just up to 2 weeks. Yes.
Deeply obliged.
I will touch, my lord.
You get a straight, will come down to orders. You tell them that, yes. Yes, Mujindra.
Lordship, on the last occasion, my learned friend has concluded his argument and he raised certain points.
You still reserve your right to reply on law?
If the need arises, my lord.
Yes.
His first contention, Lordship, is this.
One second. Today is the 10th. Yes. Yes.
His first contention was this, that single appeal against the multiple decree is maintainable. And so far the question of maintainability is concerned, it was assailed on two grounds. The first ground was this, that there is no wakalatnama and any authority on the record authorizing the government advocate to file the appeal. So far the first sub-point of this point is concerned, I concede that wakalatnama is not required in view of the judgment what is cited
Yes.
But my another sub point still remains that the appeal is filed without any authority. Authority is not there. There are more than 50 government advocates. Whether anyone can file the appeal, there has to be some sort of authority. If there is a wakalatnama, in the form of a letter, or even in the affidavit.
But how can you expect that the government advocate to act unilaterally without any instructions?
No, Your Lordship, this is a presumption. This is a presumption. And law requires that there must be some authority, otherwise in the affidavit they might state that I am authorized by the collector or the government to file the instant appeal. This point still remains.
So you're still maintaining that point?
No,
that
first
point you concede, okay, fine.
Yes.
But then the second point you still say that it disables the appeal.
It disables the appeal.
Okay.
Then, second point, Your Lordship, was that single appeal is maintainable.
Yes.
My contention, Your Lordship, is still the same. What I raised, that in this case, there are as many as 63 landowners. Though they have made one reference petitions, but it is signed by all. Separate notices were issued by the...
Just submit again. One petition.
One petition.
One claim petition.
Section 18 petition. Section 18 petition.
Signed by all 63 claimants.
All the claimants. It's not that one person has signed. It is signed by all the landowners and submitted to the collector. Submitted to the collector. It's not that one person has given the reference application.
Now you say that reference application was by 63 people, not by one person.
Not by one person.
Okay.
I'll be taking to Your Lordship to the law under Section 18 and 19 of the LA Act. Now, under Section 18 and 19, collector was obliged to make a separate reference. But he has made only
one reference.
One reference, and along with that reference, he has sent the Section 18 application asking the special judicial officer.
So you mean to say that on the part of the collector himself,
yes,
when he received the application for reference
under Section 18
signed by 63 people,
he was obliged to
make individual references to the special judicial officer.
Special judicial
There will be 63 claim petitions to be taken up individually. Okay.
Individually. Yeah. I'll show the law here.
Okay.
Individual.
Yes. References. Right.
But the court has issued separate notices to all the 63 persons. And they entered appearance and filed separate claim applications.
Okay.
Claim applications are separate. Parties are different in each claim applications, and there are certain relief which are common, but there are certain relief which are not common.
Okay.
Then, Your Lordship, each claimant has examined separate witnesses. They first examined themselves, then they examined the common witness who has also deposed in respect of individual claimants. That is the the person who has witnessed sale exhibit 456, Your Lordship. And if they have a claim relating to the damage to the civil structures, then civil engineer who has made the assessment, he was examined. So, some witnesses are common, but individual witnesses are also there, Your Lordship. Then further, Your Honor, Your Lordship, that the court has though given one judgment, but that judgment contains the individual award.
Okay.
Individual award.
One judgment, separate decrees.
Yes. No, individual award. Award.
Individual award, yes.
Individual award. And on the basis of those
awards, will have the individual award given, but with the same formula given for the entire acquisition.
Yes, formula is same.
Yes.
Formula is same, and reasoning is also same.
Yes.
But there are separate awards. Separate awards,
So
depending upon the area of the land acquired, depending upon the damage to the civil structures, agriculture products, forest products, and horticulture products. Whatever they have stated, it is there. Separately, evidence are taken. Then separate decrees are drawn. Under these circumstances, Your Lordship, my contention is this, that, and Your Lordship, while passing the order, will have to set aside each and every decree individually and each and every award in the consolidated judgments. And in view thereof, Your Lordship, I still maintain my point that single appeal against the multiple decree is not maintainable, Your Lordship. Okay. Then, in support of his contention, my learned friend has referred to two judgments. One is 2007-14 SCC 326. That copies are there, but I have given a list of book also. If Your Lordship find difficulty in locating, because he has given not in the compilation manner, he has given individually. Whether Your Lordship would like to look to that, or otherwise list of book also I have given.
2007?
2007, 14 SCC 326.
You want to distinguish the judgment?
No.
Are you relying upon it?
No, it supports my case.
Okay.
Then, Your Lordship, he referred to para 12, 13 and 14.
Yes. Para
12.
Yes. Yes.
In the case in hand, the High Court has not referred to even an iota of evidence which was adduced by the parties. There were a large number of landowners whose land was acquired, and they had filed separate objection under Section 9 of the Act and had separately sought references under cases before the reference court. It is not a case where a single case may have a large number of parties, and the evidence adduced is common for all of them. In the matter of determination of compensation, a large number of factors have to be seen, namely nature and quality of the land, whether irrigated or unirrigated, facilities for irrigation like existence of well, etc., presence of fruit-bearing tree, the location of the land, closeness to any road or highway, etc., is positioned in many rainy season, namely whether water gets accumulated in rain existence so and so. The High Court has not at all adverted to even a single piece of evidence, and there is absolutely no indication in the judgment as to how it has come to a conclusion that the finding recorded by the reference court required to be affirmed. There being total non-compliance with the mandatory provision of Order 41, Rule 31 CPC, we have no option to set aside the judgment of the High Court and remand the matter to the High Court for fresh consideration. First of all, Your Lordship will find this was a case under Order 41, Rule 31. And further, Your Lordship will also find that it is not a case where number of parties, number of landowners are parties. It's not that type of case, Your Lordship. So this judgment, first of all, is entirely on a different point, that is under Order 41, Rule 31, and the portion of which even spoke the case of the landowners. Then second judgment which my learned friend has referred, that is 2004 3 SCC. Your Lordship, I'll just take to Your Lordship this para 12. This is a case, Your Lordship, where
Pattern or same judgment 2007. Which judgment? 2004.
2004 3 SCC 85. It was a case of transfer of suit under Section 25 of the Code of Civil Procedure.
1 second. This was not cited by him. Was cited by you?
I cite that.
2000.
Just to clarify, the previous judgment 2007-14 was cited by my learned senior.
Yes.
I distinguished it.
Yes.
I don't think.
Yes,
Maybe Your Lordship. I am open to. Still, I am telling it supports my case.
Yes, that's what you assigned to support your case. And see, what happened was he tried to distinguish by saying that. Where's that part? I just. One second. Where his case was that there were separate references filed. See, he distinguished this 2007 judgment by saying that separate references were filed by the claimants. Not in your case where a single reference was filed, signed by all people. You see this 12. If the case in hand had referred, there were a large number of handles whose land were acquired, and they filed separate objections under Section 9 of the Act, separately sought references, and separately twice has come sought references under Section 18 of the Act.
Yes.
So they had sought, that was what? Separately they sought references. In your case, what Mr. Sen has distinguished is that he says this case will not help you because in your case, in this case that we have here before us, one reference application was signed by, it was a joint application by 63 claimants.
Yes.
That is why.
Yes, Your Lordship, here one line says it is not a case where a single case may have a large number of parties.
Right. It is not a case, a single case may have a large number of parties.
Large number of parties.
Use is common for all the parties.
Your Lordship will have to take the totality of the circumstances under which the case came to, these reference was taken up. Then come to the conclusion whether Your Lordship single appeal is permissible.
No, I'm just saying that.
Yes, Lordship, yes. I stand corrected. Yes. In any case, this was a case, it was a case under Order 41, Rule 31. Then, Your Lordship, the second case, which my learned friend has referred, 2004 3 SCC 85.
Yes.
85. Here, Your Lordship, it was a case under Section 25, transfer of suit. From what has happened, two suits were filed at two different places. Then an application under Section 25 was filed and both the cases were consolidated. consolidated, and therefore, Your Lordship, my respectful submission is this, that this case also has no application, Your Lordship. Now, third case which my learned friend has cited, that is relating to the Wakalatnama, which I concede, and further another case, the Wakalatnama case which is referred to 1995, 5 SCC 333, para 2 and 3, Wakalatnama, which I concede.
Yes.
Sharda Devi, that is 2003, 3 SCC 128.
Now, you have any decision on the authority?
Beg your pardon?
Authority is required.
No, Your Lordship, this is on Wakalatnama, which
Right.
my friend has referred.
Yes.
It is there.
Where the Goa judgment has been overruled.
Yes, yes, which was overruled. Overruled.
Yes.
This is Your Lordship, Your Lordship will find in para 2 and 3.
Yes.
Then another case which my learned friend has referred, 2003, 3 SCC 128, para 33. That is, collector acts as a representative of the state.
Yes.
I have no quarrel with that proposition.
2003, Sharda Devi.
Sharda Devi.
Okay, this also you concede. Fine. 1 second. I'll just. Yes. Yes.
So, these are the 4 judgments which have been cited by my learned
on a
friend.
single appeal against multiple decrees.
I have given judgment in my compilation. Those are earlier referred. If Your Lordship wanted, wants.
No, the only thing is he sort of distinguish 1007. He has distinguished it. Now he only said that you rely on it again. That's all. And you say that 2004 3 SEC 85 is a case section 25.
Yes.
So that helped the appellant.
Yes.
Okay.
And
you
other
concede
two.
that Panaji judgment.
Yes,
and
Lordship.
also this Sharda Devi.
Yes, Lordship.
Okay.
Then Your Lordship, next point,
Yes.
which my learned friend has argued, that the learned trial court was wrong in awarding the uniform rate.
Yes.
Your Lordship, so far this point is concerned, my learned friend has missed one point, that uniform rate are not awarded for the entire land. What has happened, the classification of the land is done into 4 categories. And what the trial court has found, that in one classification of the land, different rates are given. Say, for example, Lordship, arable land, arable land, or paddy field land, and in the same locality, same village, 2 different or 3 different rates are given, and which the court found is arbitrary. And no reasons are explained. No reasons are explained by the collector of awarding
Different rates.
higher compensation or different rates for different for one classification of the land. So it is not that the special judicial officer has awarded uniform rate for the entire land. He classified it.
Okay, you say that no uniform rate. Yes.
Now, he is referred to 3 judgment. I think more than this it may not be, because we have taken a complete note of his submissions. First judgment, Your Lordship, he has referred to 1972. And one more thing, Your Lordship, I will point out before I go to the judgment. Special judicial officer has not made his own assessment. He has relied on the assessment made by the collector. So collector cannot say, they cannot say that this assessment made by us is wrong. They themselves have made this assessment. The special judicial officer found that we cannot rely upon the sale deed produced by us, and there is no other material which has come from the collector's side, and therefore under the circumstances, the best possible way which according to the learned trial court was to find out the rate from the assessment made by the collector on the record. She found only one, that for categorization of the land is done, and in that different rates are there. This she found it to be arbitrary and without any basis. My learned friend has referred to 3 judgment. That is, first one is 1972, 1 SEC 480, para 4.
Let's distinguish.
Yes, Lordship, I am distinguishing it on the point that this judgment has no not applicable for the reason that in over cases classification of the land was made into different categories. But in this case, there was no classification was made. Your Lordship will just see paragraph 4. May I read, Your Lordship?
Yes.
Paragraph 4. The general principle for determining compensation have been set out in section 23 and 24 of the Act. The compensation payable to the owner of the land is the market value which is determined by reference to the price which a seller might reasonably expect to obtain from a willing purchaser. But as this may not be possible to ascertain with any amount of precision, the authority charged with the duty to award compensation is bound to make an estimate judged by an objective standard. The land acquired has therefore to be valued not only with reference to its condition at the time of the declaration under section 4 of the Act, but its potential value also must be taken into account. The sale deeds of the land situated in the vicinity and the comparable benefits and advantages which they have furnish a rough and ready method of computing the market value. This, however, is not the only method. The rent which an owner was actually receiving at the relevant point of time, or the rent which the neighboring land of smaller nature are fetching, can be taken into account by capitalizing the rent, which according to the present prevailing rate of interest is 20 times the annual rent. But this also is not a conclusive method. The court had in so-and-so case indicated at page 412 the method of valuation to be adopted in ascertaining the market value of the land on the date of notification under section 4.1. which in the opinion of expert, the price paid within a reasonable time in bona fide transaction of purchase of land acquired or the land adjacent to the land acquired and possessing similar advantage and number of year purchase. These methods, however, do not preclude the court from taking any other special circumstances into consideration, the requirement being always to arrive as near as possible an estimate of the market value. In arriving at a reasonable correct market value, it may be necessary to take even two or all those methods into account in as much as the exact valuation is not always possible, as no two lands may be the same, either in respect of the situation or to the extent or potentially not possible. Here, Your Lordship, Your Lordship will find that the method prescribed do not preclude the court from taking a different view.
And in this case, you see the special judicial officer just
took the assessment made by the collector, and has not gone on any other assessment. But what she has...
Because she could not done also because she doesn't accept the sale deeds. So what other index would you take to assess the value?
Yes, no other. And so assessment made by the collector was the only thing. But what the court found, that what it is, in the same village, my land is arable land, I am getting 40 rupees, and some influential persons like Giri Masar and all other Maori clans people, they are getting 160. For what reason? Has the reason been explained, then position would have been different. Now, another judgment which my learned friend has relied is 2010 11 SCC 581 paragraph 7.
This will distinguish.
This support my case.
Suppose your case.
Support my case.
Para
8.
Very nice.
First thing, Your Lordship, this case is not applicable for the same reason that in our case, special judicial officer has not made any assessment. So the cases which are referred by him are not applicable, because these cases will come into operation when the special judicial officer has made her own assessment. She has not made. So she relied on the assessment made by the collector. So
you see all the cases cited
on the uniform rate or on the rate have no applications. Had she relied upon my sale deed, then there was a scope for them to argue that no, those sale deeds are forged documents, or those sale deeds are not applicable, and it is not for collateral purpose, etc., etc.
Yes.
Now, I was referring to which case?
You're referring to 2010-11.
Yes, Lordship.
Haridwar development.
2010-11 SCC.
Para 8. Yes. The acquisition which we are concerned.
Yes, Lordship.
Yes.
Para 8. The acquisition with which we are concerned relate to a comparatively small extent of village land, measuring about 38 bighas of compact contiguous land. The High Court was of the view that the size and situation did not warrant any belting, and all lands deserves the same rate of compensation. The authority has not placed any material to show that any area was less advantageous situated. Therefore, the view of the High Court that compensation should be awarded at an uniform rate does not call for interference. This is clearly applied in our case, Your Lordship, because what it says that that belting system has got nothing to do, and in the instant case, the authority has not placed any material. Yeah. That land of Mr. A was more advantageous, or and B land was less. So, in absence of that, the Apex Court declined to interfere with the High Court finding that same rate should be given to all.
Belting method.
Yes. Then another judgment which my learned friend is relying is 2023 9 SCC.
1 second. Yes. This is to distinguish. 2023.
This is not applicable. 2023 9 SCC 315 para 10 and 11. The broad thing which I have told, told to Your Lordship, that here there is no assessment of the collector. Special judicial officers. Yes. The question does not arise of reference of these judgments. I'm referring 23 now. Paragraph.
You can sit down. There are enough seats if you want to sit down. Just stand at the door. Para 10.
Para 10.
Yes.
The guiding principle for determining the market value of the land at the date of publication of the notification under Section 4 in view of Section 23 of the said Act are well settled by this Court in a catena of decisions. Accordingly, the determination of market value is the process of predicting an economic event, that is, assuming a piece of willing vendor would offer to a willing purchaser in normal market conditions, but not an event of anxious dealing at arm's length, not a facade of sale, nor fictitious sale, brought about in quick succession or otherwise to inflate the market value. No doubt, for ascertaining the market value of the land, its existence, condition, location, and user, its proximity to the residential, commercial, or industrial area, etc., are the major factor required to be considered. Your Lordship, I'll take to Your Lordship that these informations are to be provided by the collector under Section 19. And he is duty bound to do it so. And I'll take to Your Lordship.
No, why do you, the claimants are duty bound to bring it? You want to show that the piece of land that been acquired, nearby it was a
yes, Lordship.
Sale price. Yes. Why should the collector bring it?
No.
Collector has just made a summary kind of assessment. It was a reference court. If the due reference court now from the evidence is tendered, then that will lead to come to a certain rate.
Yes.
Correct. Now you saying that decisions placed by Mr. Sen, it's not these decisions are not applicable at all because the special judicial officer has only taken the rates by the collector itself and given a uniform rate.
For a particular category.
For the particular, so there are 4 categories of land.
Yes.
For arable lands was 160, across the board 160.
Yes, 4 categories.
Right.
The size and nature of the land acquired and size and nature of the land in respect of which sale instances are produced on the record also would be an important aspect, in as much as normally the sale instances of small pieces of land cannot form reasonable basis to determine the market value of large chunk of land unless suitable deductions are made in respect of development charges. How much deduction should be made would depend on the matter of land in topography, special feature and state of its development so as to make it suitable for the purpose for which it is acquired. In the instant case, the tribunal, after recording the submission of the counsel for the parties and recording the sale instances on record without any further analysis of evidence or discussion.
Enhance the rate. This is the finding of the tribunal itself.
Yes.
Yes.
Then your lordship will come. The next point, yes, which my learned friend has argued, that special judicial officer has awarded interest,
yes,
on all amount. Your lordship.
That last point is what?
Uniform rate.
Interest, a uniform rate.
No, last point is on interest. I'll just.
It's the entire period.
Interest is awarded on the all items.
Okay.
All items, contrary to the provisions contained under Section 23.
Yes.
Now, I'll take lordship.
Please answer one point also, that interest was,
interest was awarded also on the amount which was already paid.
Period, and also an amount which already accepted, taken by them on objection,
yes,
whatever.
Yes, under protest.
Period 2003.
Yes.
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 That is one point also. Yes.
I'll answer that point also. It is in my mind.
Yes.
Your lordship will come first to Section 23.
I got it. Yes.
In determining the amount of compensations, here lordship will find first thing that opening words of Section 23 says amount of compensation to be awarded for land acquired under this act, the court shall take into consideration the market value. Then secondly, the damage sustained by the person interested by reason of taking of any standing crops, tree, which may be on the land at the time of collector taking possessions. That means standing crops, tree, etc. are also covered under Section 23(1) in determining the amount of compensation. Amount of compensation doesn't only mean the market value, doesn't mean. It includes all other subhead provided under Section 23. Lordship, am I clear?
Yes.
Then thirdly, the damage, if any, sustained by the person interested at the time of collector taking possession of the land by reason of severing such land from his other land. Your lordship will find here, most of the land have become useless for the reason the road goes straight. Now,
Straight from the middle of the land.
Middle of the all paddy field, it has gone. This side leaving the land little bit, and that side also leaving the land, and nothing can be done on those. Most of the plots are of this nature. And another thing, Your Lordship will appreciate that the collector has not made physical measurement and put the boundary pillar. So landowner did not know that at what point this road will go and how much cultivation is there on the acquired land because of not putting the boundary or erection pillar. Then fourthly, Your Lordship, the damage, if any, sustained by the person interested at the time of collector taking possession of the land by reason of the acquisition injuriously affecting his other property. If in consequence of the acquisition of land by the collector, the person interested is compelled to change his residence. Sixthly, the damage, if any, bona fide resulting from diminution of the profit of the land between the time of publication of the declaration under section 6. So, Your Lordship, the compensation here to be awarded is not confined to the market value. It includes all the sub-head provided under section 23. That is the compensation. Then Your Lordship will come 1A, 23 1A. In addition to the market value of the land as above, provided the court shall in every case, the court shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of the publication of the notification under section 4, subsection 1, in respect of such land to the date of award of the collector or the date of taking possession of the land, whichever is earlier. Explanation. In computing the period referred to in subsection, any period or period during which the proceedings for the acquisition of the land were held up on account of any stay or injunction by the order of any court shall be excluded here. Your Lordship will find under 23 1A, in addition to the market value, the court in every case shall award an amount.
See, amount means from the date of the publication of the section 4 notification
and
to the date of the award.
Date of award,
yes,
or date of taking possession, whichever is earlier.
The award. Okay.
Whichever is earlier. Whichever is earlier.
Yes, or taking possession, yes.
And here, Your Lordship.
Not for the entire period.
Not for the entire period. I am highly obliged, Your Lordship. It's not for the entire period. Yes. And in that period also, initial period, supposing the party has gone to the High Court for any such matter, and there is a stay, then that period will be excluded, Your Lordship.
Yes.
Now, my submission, Your Lordship, under section 23 1A is this.
Yes.
That in the instant case, the court has not awarded any amount under section 23 1A. And my prayer to this honorable court is this, that this is mandatory and statutorily required to be awarded. Even I am not required to file any cross appeal or for separate appeals. The moment the land is acquired and the market value is fixed, I become entitled for an additional amount of 12% on the, not on the compensation, Your Lordship. They don't use the word compensation. They say 12% on the market value of the land. Now, this amount is not awarded to me, and I'm entitled for this amount, I most respectfully pray to this honorable court to take note of these provisions and award me interest. This is not an interest, Your
Additional
Lordship.
interest.
This is additional amount. It is not an interest. Then Your Lordship will come to subsection 2. In addition to the market value of the land as above provided, the court shall in every case award a sum of 30% on such market value in consideration of the compulsory nature of. This talks about the solations, Your Lordship, 30% under subsection 2 of section 23, Your Lordship. Then, Your Lordship, so what we get, Lordship, here, under section 23, we get no provision for award of interest. Award of interest is separately dealt. Here we get it only additional amount at the rate of 12%, which is not an interest. It is.
What is factored in interest, in addition to market value of the land above provided, the court shall in every case award amount calculated at the rate of 12% per annum on such market value.
It is not on account of any interest. It is an independent provision.
You have any authority on this?
Yeah, I'll show you. I hopefully believe I'll be able to satisfy this court.
Yes.
Then, Your Lordship, interest provisions are provided under section 34 and read with section 28. Let's see first section 34, because section 34 controls section 28. Section 34, payment of interest. When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with the interest thereon at the rate of 9%. Here, one thing, Your Lordship, before I proceed further, section 34 talks about compensation. It doesn't talk about the market value. It talks about the compensations. When the compensation is not paid, here the compensation does not mean only the market value. It includes all these 6 subheads provided under section 23.
Yes.
When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with the interest thereon at the rate of 9% per annum from the date of taking possession until it shall have been so paid or deposited, provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on such possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of compensation. Here again, Your Lordship, it uses the word compensations, or part thereof, which has not been paid or deposited before the date of such expiry. So, payment of interest at the rate of 9% or 15% is on compensation, determined in accordance with 6 subhead of section 23.
So you say compensation is totally different. So how it's computed, whether these other amounts were taken into account, that amount will be the whole basket of compensation.
Yes.
And then interest, a separate component, which is levied on that compensation.
Yes,
not
on
that
the
it
compensation.
Not that it goes hand in hand.
And here, Your Lordship, this compensation will also include the solatiums granted under section 28(2) and no, I'll show you. I'll come here, Lordship.
Yes.
I'll come. There is a specific judgment of the Constitution bench which says that solatium is a part of the compensation.
Just to cut it short, I have never raised this point at any stage. I'm admitting the point that under section 28, when interest is applied, it includes all the 6 heads, including solatium.
Okay.
That's never been my contention.
No, now what Mr. General is trying to argue is that
Lordship.
Now you're saying interest was paid entire amount on all, that's your arguments, correct?
Yes.
So entire period, entire amounts, 28%, 9%, under section 28, 9% was given,
Yes.
right? Like, so that is, that is, you see that it amounts to additional compensation because statutory compensation is limited, correct?
Lordship.
Yes. Now what Mr. General is trying to argue is that compensation is a totally different aspect altogether, how it's computed. And so this whole, the basket of items that is there,
Yes.
so how it's computed, that is entirely outside the ambit of interest. And interest then later on is, factored on the entire
amount.
Entire
I'll
amount.
just clarify that, Lords. Under section 23(1),
Yes.
Lordships will find there are 6 heads: market
Yes.
value and other losses. Then there is 23(1)(a), which is the statutory amount that is paid
Yes,
to offset
31.
inflation. That is only for a small period of 1 year.
Yes.
Then there is solation under subsection 2. All of these put together form compensation, which is that word appearing in section 23 and section 34. I am admitting the position that when interest is applied under section 28, it is applied to
Entire
all
basket,
the amounts.
yes.
That I'm not disputing that position.
No, but
even on the last
but
occasion,
Mr. General, see how that compensation is arrived at.
Lordship.
That's the only thing.
No, my argument will may just make it clear again.
Maybe it's on is on parallel. How can they become parallel on parallel points?
Lordship.
In the sense that Mr. General is saying why interest has been, what do you call it, the compensation that has been given is, what do you say? Coming back to section 23.
23.
1A, yes.
So may I just clarify, Maraj? Under section 23, they were awarded interest for market. They were awarded compensation for market value and certain damages, which is under section 23(1), subsection 1. Under subsection 1A, they were not paid that additional amount. None of the landowners in the entire award. Nobody was paid. They never made a claim. There is no whisper of that in their pleadings anywhere. It's
Not
a whole
required.
other thing whether it is a statutory payment or not.
Required.
That's
not required.
that's another thing. But the fact remains in their cross appeal as well. There is no pleading that they were not paid this 12%. Number one, I was quite surprised that they have not claimed this 1A. This payment of 12% under 1A has not been. My lords, kindly see, there are only 47 people before your lordships. Only those people. What about the rest? In their appeals, nobody's praying for this.
I'm praying no.
That has come in now because on the last occasion I clarified that 1A is not interest. It is a statutory amount which is granted to offset
9%.
to offset inflation, and it is only for a period of 1 year. So it is distinguishable from interest, which is applied under section 28A. Now my argument was when the collector grants interest for that initial period of 1 year, he can only grant the prescribed rate of 9%, not 12. That was my argument, Lords.
Okay.
And I'm saying it will apply to the entire interest, no doubt. But in this case, they were not granted the 12% under 1A. Now my learned senior is orally making that submission because I made that clarification on the last date.
That was confusing the court.
Yes,
Because
that is what is confusing here.
Yes.
What my learned senior said, if your lordships will recall, interest for that first period was granted at the rate of 12%.
Yes.
So I agitated that the Act does not prescribe 12%, it only prescribes 9%. So they traced it to 1A. And I distinguished 1A by saying 1A is a statutory compensation which was never given to any of the landowners. It is not interest, which my learned senior is conceding now, that the grant of that 12% under 1A is different from compensation, which is also my case, which is different from interest, which is also my case. 1A is not interest.
Okay,
Interest is only under 28.
Please continue, Mr. Jindal. Yes.
So, Lordship, may have a look on section 28 now.
Why do you say 34 governs 28?
Because, Your Lordship, provisions in both these sections talks about the interest on
excess compensation.
What is the
28 talks about excess compensation.
difference here, Lordship?
If the sum which in the opinion of the court ought to have awarded.
Here only the phraseology is used different. Here in section 28, Your Lordship will find that collector may be directed to pay the interest on excess compensation. Now, section 34 talks about deposit, payment of interest. That slight difference is there here. Otherwise, the operating things.
The purport, you mean?
Purport of the section 34 and 28 is similar. Only difference, Your Lordship, which I could found, that in section 28, direction is given to the collector to pay interest on the compensation awarded. Now, when section 28 phraseology is used, my understanding is this, that interest cannot form the part of the award. It is a direction to the collector to pay interest. And when in 34 it is, the phraseology is used, it becomes the part of the award. That, I am open to corrections. Otherwise, I did not find in substance the difference between these two, save and except that the heading of two sections are different. Collector may be directed, and here payment of interest. There is no direction. No direction here.
But then I really maybe, okay, I want to air my course views right now. Because
No,
I don't think
if
that paramateria, I don't think they are similar. Because it's on two different.
I can clarify that very quickly, my lords.
On
Please have the act, just the index of the act.
Yes.
Just have the index of the act, my lords. I'll clarify it right away.
It's on two different.
Yes, I'll point out what the difference is.
Yes.
It's a very simple difference, my lord. If your lordships see the index of the act, your lordships will find part 1, part 2, kindly have part 3.
Reference to court.
Yes, so this starts from section 18 to section 28A.
Yes.
So section 28, which is the collector's power to grant interest in a reference proceeding. So it is the 28 is the power of the collector to impose interest. And if your lordships see part 5 with regards to payment, that's where section 34 features. This is the power of the collector to grant interest. That is the basic difference.
Power with the direction.
No, I'll come to that, my lords. What happens is, when the award is determined by the collector, he is duty bound to grant interest on that under section 34.
Okay, yes.
For whatever the period may be. Again, it's 9% and 12%. But when it comes in a reference proceeding and the court finds that the amount should have been higher, then the court issues a direction for the payment.
On excess compensation.
On the excess compensation. Because under section 34, say the original award is 100 rupees. Interest has already been applied there. Now, when it goes to the court in a reference proceeding, under section 28, the collector grants interest only on the excess compensation. If at all, there has been a grant of an excess compensation. So, if from 100, the court decides to grant 200, so that award of interest under section 28 will be on the additional 100. Okay. That's the only difference between these two.
Yes.
Lordship, may I have a look on section 27 also, cost. Every such award shall also state the amount of cost incurred in the proceeding under this part and by what person and in what proportions they are to be paid. When the award of the collector is not upheld, the cost shall ordinarily be paid by the collector unless the court shall be of opinion that the claim of the applicant was so extravagant or that he was so negligent in putting his case before the collector that some deduction from his cost should be made or that he should pay a part of the collector's cost, Your Lordship. Here, Your Lordship, we are also entitled for cost. And the objection still will remain of my friend that it is not claimed. It is not claimed. And therefore, it cannot be granted. My submission is this: I am not required. This is, if it is pointed out to the court at any stage of the proceeding, even before the apex court, if it is pointed out that cost and the additional amounts are not granted, the court will take a note of it and will grant, because these are the statutory things, Your Lordship, for which no pleading is needed. And
since by operation of law, I think.
This is by operation of law. Operation of law. Your Lordship, so far the interest part is concerned, I'll refer the judgment of 2012, 5 SEC 432. Meherwal Kaveri Trust Register. Here, Lordship will see paragraph 25 and 26.
Yes.
This aspect has been considered and answered by the Constitution Bench in Sundar versus Union of India. While considering various decisions of the High Court and approving the decision of the Punjab and Haryana High Court rendered in the state of so-and-so, this court held that the interest awarded under Section 28 would include within its ambit both the market value and the statutory solatium. In view of the same, it is clear.
This is interest and aggregate amount, yes.
Yes. It is clear that the person entitled to the compensation awarded is also entitled to get interest on the aggregate amount, including solatium, Your Lordship. Then, Your Lordship, the Constitution Bench judgment which is referred here
Sundar
is 2001 7 SCC 211. Para 14 and 15. Your Lordship.
Yes. Para?
Para 14.
Yes.
Question of payment of interest could arise only when the compensation is not paid or deposited on or before the date of taking possession of the land. It is inequitable that the person who is deprived of the possession of the land on account of acquisition proceeding is not given the amount which law demands to be paid to him. Any delay thereafter would only be to his detriment. There must be a provision to buffet such inequity. It is for the purpose of affording relief to the person who is entitled to such compensation when the payment of his money is delayed, that the provision is made in Section 34 of the Act. That section is extracted below. Section 34 is extracted. Then 15. When the court is of the opinion that the collector should have awarded a larger sum as compensation, that's the difference your lordship will find. Para 14 talks about 34 interest and 15 talks about interest rate 28. When the court is of the opinion that the collector should have awarded a larger sum as compensation, the court has to direct the collector to pay interest on such excess amount. The rate of interest is on a par with the rate indicated in Section 34. This is so provided in Section 28 of the Act. Section 28 is extracted. 16. Thus, interest has to accrue as per Section 34 and Section 28 of the Act on the compensation awarded, whether it is as per the award initially passed by the collector or by the court later. What is meant by compensation awarded? Both sides cited different definition for the word compensations. Compensation as contained in different lexicographics in words. I just slip and come to then it is fair market value at the time of taking it. From the constitutional perspective, the word compensation for the property taken was understood as the just equivalent of the value of the property, but when compensation is regarded as a statutory obligation, the aforesaid definition did not detract the courts in forthcoming the real import of it. The exercise can be done with the aid of the provision in the statute. So what the court in the context of land acquisition has to decide is how the Act had designated the compensation vis-a-vis the liability to pay interest. In this context, we have to read Section 23 is read. What are the paras? 16 and 19. Then your lordship, paragraph 16.
16?
16.
Reading 16 just now?
I have already read. Yes, I come to your lordship, paragraph 19.
Yes, section 26.
Section 26 does not say that the award would contain only the amount granted under subsection 1 of section 23. The special mention of that subsection in 26 is only for the purpose of directing that the grounds or reason for awarding the amount under each of the clause in the subsection shall be specified in the award. It is unnecessary to mention any reason or ground in any award as to why the sum indicated in subsection 1A and subsection 2 of section 23 of the Act were granted, because they are only the sequels or concomitants of the determination of the total amount indicated in subsection 1. No judicial exercise is required to quantify the same mentioned in subsection 1A or subsection 2, because the section itself specifies the percentage to be worked out for the purpose of adding to the total amount arrived at under subsection 1. Otherwise, section 26 is not intended to show that the compensation awarded would be bereft of the additional amount and the solution envisaged under subsection 1A or subsection 2. This can be clearly discerned from the commencing word of section 26 itself. They are, every award under this part shall be in writing signed by the judge. What is referred to there in part 3 of the Act, which comprises of a 12 provisions starting with section 18 and ending with 28A of the. There can be no doubt all the three heads specified in the three subhead of section 23 are the sums to be awarded by the court. Hence, the word every award under this part cannot be treated as the award after delinking the amount awarded under subsection 1 or subsection 2 of section 23. So this is your lordship constitution bench judgment, and specifically the paragraph 19, which says that no judicial exercise is needed. They are the
there's a right.
Sequels of concomitant.
Yes. So no
Then-
judicial.
Yes, lordship. Then your lordship, another judgment which I would refer, 1991, 1 SCC 262.
On the same point.
Is a distinction between, I think, interest under section 28 and 34 and cost also under section 27.
Distinction between
Interest under section 28 and 34, cost under section 27.
and cost under 27. Just give me 5 minutes. Yes. Let's come back. Yes. 1991-1202. Yes.
1991, 1 SCC 262, no?
Oh, 262, sorry.
So, Your Lordship will come to paragraph 13.
1-3.
1-3. There is no doubt that under the Act, Lordship, got it.
Yes, yes.
There is no dispute that under the Act, the claimant is entitled to compensation at the rate of the market value of the land on the date of
Notification.
on the date of notification under Section 4 of the Act. Section 23(1) of the Act enumerates the matter which are to be taken into consideration in determining the compensation. On a reference under Section 18 of the Act, the parties go to the trial before the court primarily on the issue of determination of the market value of the land. So far as award of interest is concerned, it is never an issue between the party. Once the condition under Section 28 or Section 28 of the Act are satisfied, the award of interest is consequential and automatic. It is automatic. Then 14. The High Court...
But he did not place his judgment earlier on.
Lordship?
He had not placed it earlier on, his judgment.
This one earlier was not.
It's not a compilation.
It's not in the compilation.
Yes.
No, we can supply the copy if Your Lordship...
No, it's just that there's a good judgment. That
Yes, that's why I have given the list of book.
Yes.
The para 14. The High Court, while appreciating the point in issue, did not consider the mandatory provision of Section 34 of the Act. That said section specifically provides that when the amount of compensation is not paid on or before taking possession of the land, the collector shall pay interest at 6%, now it is 9%, this is earlier judgment, from the date of taking over possession. The payment of interest is not dependent on any claim by the person whose land has been acquired. I read once again, Your Lordship. The payment of interest is not dependent on any claim by the person whose land has been acquired. There can be no controversy and any list between the parties regarding payment of interest. When once the provision of Section 34 are attracted, it is obligatory for the collector to pay the interest. If he fails to do so, the same can be claimed from the court in proceeding under Section 18 of the Act, or even from the appellate courts thereafter. We have carefully examined the reasoning of the High Court in reaching the conclusions which we have reproduced in the earlier part of the judgment. We do not agree with the interpretation placed by the High Court on various provisions of the Act. Reading Section 23 with Section 26 of the Act, it is clear that the award which is deemed to be a decree is the sum total of conclusions reached by the court in determining compensation under Section 23 of the Act on appreciation of the evidence between the parties. Then the costs under Section 27 and the interest under Section 28 and 34 are added to the compensation amount to make it consolidated award. The cost and interest under the Act, if not awarded by the lower court, can always be awarded by higher courts in any proceeding under the Act and to any party entitled to the same under the Act. I may read para 16 also. There is inherent evidence in the wording of Section 28 and 34 to show that the framer of the Act intended to assure the payment of interest to the person whose land was acquired, and it was not the intention of intention to subject the said payment to procedural hazard. Section 34 lays down that the collector shall pay the amount awarded with interest at so and so %. The legislative mandate is clear. It is directive to the collector to pay the interest in a given circumstances. Section 34 nowhere says that the interest amount is to be included in the award decree as prepared under Section 23 read with Section 26 of the Act. Similarly, Section 28 provides that the award of the court may direct that the collector shall pay interest. Here also the award under Section 23, read with Section 26, has been kept distinct from the payment of interest under the section. The interest to be paid under Section 34 and also under Section 28 is of different character than the compensation amount under Section 23(1) of the Act. Whereas the interest payable under the Act can be claimed at any stage of the proceeding under the Act. The amount of compensation under Section 23(1), which is an award decree under Section 26, is subject to the rules of procedure and limitation. The rule of procedure are handmaiden of justice. The procedural hassles cannot come in the way of substantive right of citizen under the Act. If I am entitled, I am entitled as per the law.
Oh, that's clear, yes. Good judgment, this one.
Yes.
19, this is, how many? This is, or 2 judges, one.
Then, Your Lordship, to make the matter, my learned friend has also referred one judgment that the court failed to exercise the discretion.
You want to distinguish?
2011 4 SCC 363. He referred to para 29. Your Lordship, my submission is this, Your Lordship. He says that judgment remained pending for 2-3 years because of the change of the presiding officer. And therefore, while exercising the discretion to award the interest, the trial court ought to have taken into consideration the period for which the judgment should not be delivered. Now, my reply to that judgment is this, Your Lordship. If Your Lordship will look to the entire proceedings, on each stage, the collector was at fault. He has not followed any of the provision of acquisition of land. Right from the time notification under Section 4 was issued, and Section 8 is totally ignored, Section 12 is totally ignored, and Your Lordship will find in this case, collector has not published any award. He issued only notice, they come and take this money. And copy of the award was asked by the court and not produced. Even as on date, the award is not on the record.
Okay.
And therefore, the exercise of discretion of award of 15% does not call any interference by this honorable court. Under the entirety of the circumstances, the learned trial court was justified in awarding interest at the rate of 15% for the entire period. 22 years, Your Lordship, more than 2 decades. And 5 years the case remained.
No, that means he awarded interest in the entire period from 2003.
Yes.
Till the time of the
decree was prepared.
Decree is prepared by the SGO.
That comes around 21
also,
years.
But then the thing is that can it just be on the reason of laches and preparation of award? Will it be be settled with that?
Lordship, laches on whose part?
Whatever it is.
Laches on the part of the collector.
Can that be attributed to the collector? When the courts had changed and the court not passed judgment for a certain period of time, can that time period be added on to?
Your Lordship,
or since it's
Your Lordship will see.
If
the
you have
ground,
any other judgment that
what
shows
is the ground reality? What happens, Your Lordship? Adjournments are sought by the collector of the state time and again. They do not file a written statement. At least minimum thing which is required. They don't file.
Yes, that is seen.
And they don't produce the record. Time and again notices are sent. They do not produce the evidence. 5 years they start taking time. And ultimately the government advocate appears before the court and says that collector's instructions are this, that we are not going to use any evidence, any evidence. And if the court abruptly closed the evidence, they will get a chance to come to the High Court for remand of the case. That's what your lordship happens. Happens.
Well, that's what I see.
These are the
last time court had also observed that maybe since there's so much lacuna here, maybe we can remand it on certain, on certain issues.
I'll come to that.
And to reappreciate. But you have said no. That'll cause too much agony to the claimants.
Yes.
Where they've suffered enough for 20 years.
Yes. That part,
that
part also, your lordship, I will address to this court.
Yes.
Then, your lordship, with regard to the other claim.
No, how do you distinguish this judgment? This 2011, you've not distinguished it.
Which case, sir?
The 2011 4 SEC.
2011 4 SEC 363 para 29. My submission is this, that court has rightly exercised the discretion.
Okay.
In awarding 15% interest.
Yes.
Taking the entire nature of the proceedings, and your lordship, measurement and putting the erection pillar is the job of the collector. He has not done, and that application he referred to the special judicial officer. Then special judicial officer was burdened with getting the measurement and boundary pillars fixed, and that took more than 3 years before evidence could be started. This was the job which the collector ought to have done. He has not done. Then, your lordship, another point, your lordship, very important point which my learned friend has made out, that we have claimed compensation on account of damage to civil structure,
yes,
forest product, and horticultures and agriculture. And my learned friend says that these are the claims which were not referred to the collector, and therefore the collector lacks inherent jurisdiction to pass any award relating to these items, and his only submission is the question of the lack of jurisdiction.
Like it's only for the gate and for the wall.
Only for the gate.
But gate and the wall, but then the trees are taken consideration and.
No, he said that nothing is referred with regard to this. Even iron gate.
For the gate and the wall, correct.
Well, if you actually look at the reference application under Section 18, this gate and wall and all is not mentioned anywhere.
Okay.
But there is a mention of horticulture and trees and cultivation. That's there. But in the reference order, none of these things are mentioned. So we have to go by the reference order, unfortunately.
That point, yes, Mr. General, you have to answer.
Yes.
The special judicial officer has to go in terms of reference has been sent by the Deputy Commissioner.
Yes.
And
not
so
by the forwarding letter.
Yes, whether it was correct in ascertaining,
No.
fixing compensation for things not referred.
No, Lordship, it is
Yes.
not correct. Now, my submission is this. Volume 1. Section 18 application. This is not application. Your Lordship, my application under Section 18.
Paper book 1.
Book 1. is at page 90.
19.
No, 90.
Yes.
So, I'm sorry, just a minute, I'll correct. Page 96.
Yes.
Now, this is in section 18 application. Paragraph 4, your lordship will see. Paragraph 2 also your lordship may say that the petitioner landowner state that the government of Meghalaya in the department of so-and-so acquiring land measuring so-and-so more or less of the village so-and-so, that is for the construction of national highway as per the details given so-and-so. Thereafter the government also issued notification number so-and-so under section 6 of the Land Acquisition Act 1894 and made a declaration of intended acquisition without disposing the objection filed by some of the landowner and without hearing the objection, your lordship. So, with regard to section 6, we have taken the objection that the petitioner landowner stated that during the process of making declaration under section 6 of the LA Act from the date of notification was issued, there was substantial damage to land crops of the various landowners and no payment for such damages was made to any of the landowner as is provided under section 5. That the petitioner landowner states that without taking any actual and physical measurement and without classifying the category of the land and without assessing the value of the standing crops, tree and other cultivations, the petitioner landowner were made to sign on certain forms and the representative of the landowner filed a writ petition number so-and-so before the Shillong bench of the Guwahati High Court, directed then Honorable High Court wide order dated so-and-so to proceed with the acquisition proceeding in accordance with the provision of the Act as amended, to intimate the concerned landowner about the measurement and classification of the land as contemplated under section. So we have specifically taken this point to your lordship. Then your lordship will come to page 98A. Paragraph 5. That the petitioner state that no demarcation of the landowner was made by the collector and to boundary pillar of the landowner were fixed and no measurement of the land was physically taken by the collector. The land was also not classified, no assessment of the standing crops, other cultivation was made as was mandatorily required under section and no landowner was informed about the measurement, classification, etc. of the land done by the related law and as per order dated 14/11/2002 passed by the Honorable High Court. That the petitioner landowner states that without complying the requirement of section 8 and of the order dated 14/11/2002 of the Honorable High Court, the Honorable Collector purportedly prepared the map and the plan relating to the land issued. The notification was purported to be notification under section 9 of the Act, but the said notice was not in accordance with the requirement of law, inasmuch as the particular land of the individual landowner were not there. Then your lordship will come.
Come to the prayer.
Yes, your lordship.
Yeah.
In the premises, it is therefore prayed that your honor would be pleased to make a reference to the special judicial of Meghalaya for determination of the actual measurement of the land, classification of the land, demarcation of market boundaries, market price of the land, and building is mentioned, your lordship, building, standing crops, tree, cultivation, etc. and allow the landowner petitioner to withdraw the amount. Your lordship, this petition is signed by all the landowners. Then, Your Lordship, I take to page
108.
107.
This 1 through 8, yes. This is 1 through 8 is the
signature of all the landowners.
1 through 8. Come which 1 through 8? I remember this lastly because we had, I think it was shown by Mrs. Sen last time.
Yes. Yes. And next sheet, page 101. Is the
What is nature objections to award for determination of measurement classification the rate of land in the locality? That is the objection taken by you at that point of time.
Yes, Lordship. Instead of disposing some of the points which collector was required to do, what he has done, he has sent this application to the special judicial officer for taking necessary action and disposal. Come to Your Lordship, page 107.
Yes.
This is the letter dated 31st October 2003. With the reference to above, I have the honor to forward herewith an application under Section 18 of the Land Acquisition Act, filed jointly by one Shri Armstrong Same of so-and-so village and 67 other. Having perused the application, I am to make the following observations. That part 1 of the application claiming to have been, this is given. Lastly, Your Lordship, I read it, last para. The application under Section 18 of the Land Acquisition Act is accordingly enclosed herewith for favour of kind necessary action and disposal at your end. So, he forwards this application for disposal in accordance with the law at his end. Then Your Lordship, on page 108,
yes,
he makes a reference.
Yes, that's the references.
He fill up, this is the statutory form, maybe, I don't know. Then he says that ground on which the amount of compensation was determined in the case of objection to the amount of compensation. Amount of compensation was determined on the basis of the fair market value of the land at the time of assessment. Then he refers to that for nature of the objection taken to the award, for determination of the measurement, classification,
and the rate of the land. So you ask only for the area and for the classification of different types of land.
He goes
That's the whole objection.
he goes contrary to the objection taken under Section 18.
But was that taken up before?
I will come to Your Lordship that what Section 18 application should contain and what reference under Section 19 should contain. Then the matter will be clear. Whether reference...
So how did the special judicial officer deal with this aspect?
This aspect,
there
because
was no specific reference with regard to loss of trees and buildings.
That is what Your Lordship I have pointed out at page 96.
Yes.
That this application is forwarded to is sent to the special judicial officer for disposal.
And this is a general application because signed by 67 people.
Yes.
And it is a general, references made to land and buildings.
Yes. Yes.
But there's no specific reference with regard to,
Your Lordship, this is what? 97 page. Had he not forwarded this application, then I would have to some extent state that only this thing. The application is forwarded.
Of course, I think forwarded. But
and this is forming part of the reference.
Now before the...
And on the same date, the same date, Your Lordship will find that this page 108 is signed. Same date.
Yes.
Same date. And it contains the area and the amount. And then your Lordship will just have a look on page 112. Rates are given, rates are given, area is given, and amount at column 5, amount is worked, then 12% interest with effect from 13/9/2001 to 7/7/2003. 7/7/2003 is said to be the purported award. And here the collector gives 12% interest, whereas as my learned friend has submitted, it should have been 9%, but he has given 12%. Then the amount payable. Now, this being the positions,
yes,
being the position, I'll take to your Lordship to section 18. Reference to court. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the court whether his objection be to be of measurement of the land, the amount of compensation, the person to whom it is payable, or the apportionment of the compensation among the persons interested. Then subsection 2. The application shall state the ground on which objection to the award is taken, provided that every such application shall be made if the person making it was present or represented before the collector at the time when he made his award within 6 weeks. In other cases, within 6 weeks of the receipt of the notice from the collector under section 12, subsection 2, or within 6 months. These are two not relevant, only subsection 2. The application shall state the grounds on which objection to the award is taken.
Yes.
My duty is only to state objection, that these are my objections. No, I'm not a party to this, that format which he has used. Now, if I have taken an objection, that requires a decision. And my duty is only to state the objection, and I have stated the objection. Then under section, when this application...
See, the thing is that the objection should be to an award. Now you see there was no award.
Pardon, sir?
The objection
Yes.
should be to award.
Yes. Award is never given. I do not know. They never produce in the court also. They never produce in the court. And they have not given me the copy. And under section 19, what minimum the collector is required. I'll take to your Lordship that very pertinent point.
Yes.
That what section 19 requires. Come to your Lordship, section 19. Collector's statement to court. In making the reference, the collector shall state for the information of the court in writing under his hand the situation and extent of the land with particulars of any tree, building or standing crops thereon, which he has not done, the names of the person whom he has reason to think interested in such land, the amount awarded for damages and paid or tender under section 5 and 17, and the amount of compensation awarded under section 11. the amount paid or deposited, then D. If the objection be of the amount of compensation, the ground on which the amount of compensation was determined. I am putting emphasis on clause A and D. That he has to give the situation where the land is situated and extent of the land with particulars of any tree, building and standing crops thereon. And D, if the objection be
So, okay,
to be,
Mr. Jan, this was not done. Then we don't want to rewind the entire process. This was not done.
Yes.
At a point of time, your submission maybe is accepted that when the award was made and when the reference was made, Section 19 was not complied with.
Yes.
There was no compliance in the sense that there was no definition of the separate plots of the claimants. Number one. Number two, no measurement. Number three, there was no demarcation. Number four, there was no details given about the trees and other buildings, whatever that was there in the land. For which they could make a subjective kind of a objection.
Yes.
So okay, fine. That is gone now. Sitting now here where we are, how do we go forward then? We're not going to go there. How do we go forward to
Your Lordship will have to draw some inference.
How to draw inference? Now, how we draw inference now with regard to this, with regard to these things which are never mentioned on your part also, it was incumbent also if there was there was what do you call it, a lapse on the part of the collector. Now, whether you should have put that in the reference petition that the claimant number one, that land and the gate and the wall and the bamboo and that kind of thing.
Yes, Your Lordship.
Yes.
One thing is
because we can't go back. Now, in this case, it's totally fluid.
We are not going
it is
back,
not a
Your
question where procedure followed like to the letter.
There are certain fundamental things.
Yes.
Especially with regard when the objection is taken with regard to the rate.
That is why now we have to go only from that base.
With regard to the rate, and it is obligatory on the part of the collector.
That was not done.
No, under subsection 2. Not done, then what happens?
Exactly what happens?
And that's what I will tell you. That's what, Your Lordship, I am here to convince this court, then what happens?
Yes, then what kind of inference can the court draw to say that the amount awarded was justified?
Can a collector take the benefit of his own wrong?
That's another aspect. But whether what
on
inference
wrong
can the court draw,
and
or
whether
what
this
can the
is
court exercise to award certain amount of compensation,
this
which
is
was
done,
never there in the reference.
Whether this is done intentionally or otherwise,
we don't know. Their submission is that court special judicial officer can adjudicate and award compensation or enhancement only on the terms of reference that have come before the court.
Have they raised any such objection?
What has happened
Have they raised any such objection before the trial court?
It has gone beyond the SGO has acted in excess jurisdiction in awarding certain compensations which were never referred to it. That's all. So we have to address the point.
That on what basis he has a right.
Yes.
On what basis he has a right. That is the most essential part.
Exactly.
Most essential part, which is missing.
Yes.
And what will be the consequences of that?
Yes. You're right. They can't take advantage of their own latches.
I'll refer three judgments. I'll start with Your Lordship, I'll just refer first that.
What is the citation?
Your Lordship, this is CWN.
Calcutta Weekly Notes?
Yes.
Must be of considerable vintage then.
Yes.
Exactly 1905.
Then Your Lordship will just see, come to page 876. Page 876. Last line. It is generally necessary to take two Harishchandra Nogi and so, no, sorry,
Yes, then it has to take
two or all of these method of valuation in order to arrive at a fairly correct valuations. Exact valuation is practically impossible. The approximate market value is all that can be aimed at. Now the arbitrary rule of onus propendi is, in these cases is that the claimant who is a plaintiff must prove that the valuation made by the collector is insufficient. The theory is that the collector in arriving at his award performs administrative and quasi-judicial functions. He may take evidence and come to a conclusion on such evidence. The award under Section 11 of the Act becomes final. If it is not challenged within a definite time before the tribunal of the special judge, and that judge therefore fills the position to some extent of an appellate court, the burden of proof is thus ordinarily on the claimant in the court of the special judge. But the burden must vary according to the nature of the inquiry made by the collector. If no evidence has been taken by the collector, and if no reason have been given in his decision to support his conclusions, the claimant has a very light burden to discharge. The mere ipse dixit of the collector has very little weight and is not prima facie evidence of the correctness of his award. Instances are not uncommon where the collector has not given the ground on which the amount of compensation was determined by him, and the legal result of his failure to comply with the provision of Section 19(1)(d) of the Act is to make it incumbent on the collector to justify before the special judge an award which is a mere brutum
What does
fulmen.
brutum fulmen mean?
Yes.
What does it mean?
Sir, I have to see.
You can Google it. First time I come to this word brutum fulmen. Sounds more German than Latin.
I don't know.
Yes.
But that sense we can make it. Here, Your Lordship.
Empty threat.
Eh?
An empty threat.
Empty threat.
I don't think it's apt.
An ineffectual legal judgment. That's what it
Ineffectual legal judgment. So Your Lordship, I'll explain what it is.
Yes, no, we get the general idea.
General idea
Like,
we get
which
it.
is a what?
That-
I mean, it's
that-
an
that-
empty,
that-
like you know, it's
and
just
the
a
legal
judgment which is
no,
empty of reason.
last
That's
para,
all.
and the legal result of his failure to comply with the provision of Section 19(1) of the Act is to make it incumbent on the collector to justify before the special judge an award which is merely
Which is empty, is without reason.
Yes, which is empty, and which in the instant case has not been done.
Okay.
And a very sound reasoning has been given. Whatever may be the citation of this case, but
Interesting.
What's
What's the citation? Is Catholic
yes.
Weekly Notes? CWN. We'll have to refer to it. Huh?
Yes. Then
the numbers are given.
Pardon, sir. 1907 11 CWN 1907 1907
CWN
CWN 875.
Okay.
Then, Your Lordship, another judgment that 1991 to SCC 247, para 6 and 7. Hmm? 1991.
I thought it finished today. By
I
12
also
o'clock.
thought, Your Lordship, but what has happened, so many judgments are there which my friends have cited. So many judgments are there which my friends have cited, and something new has come up in my mind.
It's like they say, the toothpaste, you keep on squeezing, more and more comes out.
The
When
more you
think-
read, the more
when you
it
think
comes.
it's over.
The more you read, the more it comes.
Yes, the more you squeeze toothpaste, it still keeps on coming on. You can still use it.
Lordship.
Yes.
Paragraph. Para 6.
Yes. I was thinking that today we'll close it and reserve for judgment. But
there are some,
dragging this court
there
into
are some
deeper and
very
deeper waters
there
now.
are some very interesting points here. There are some.
They are very interesting points, especially
Very
the judgment you
interesting
cited that that judgment which was earlier, that was very good judgment, which regarding that there's no need to make a claim for interest.
Yes.
Once compensation has been fixed,
Yes.
I mean interest is signed, like it is, it's a
And,
natural corollary.
additional amount under
Yes,
section
yes,
23
that's a
1A.
corollary. That is a very important. You have to.
In fact,
You'll have to answer on that point.
I switch on to the other point. I left out the factual thing on the award. My friend has referred to the decree, not to the award. What the trial court has held with regard to the interest. He straightway took this court to the decree. So,
But one thing, you should have argued these points when initially. Exactly regarding.
No, Your Lordship,
19.
this point came up when he has raised in his argument that there is no reference. Now, Your Lordship, this thing which is required to be mentioned under section 19 has got some meaning. It's not some meaning, it is a base on the basis of which the special judicial officer will have to make the award. The extent of land.
But the judgment says to a certain extent, if that was not done, if that was a brutal form
And
judgment, then if it comes for a special judge, then your duty is lightened because, to...
What the court has done, that they said that, all right, collector, whatever way he has made the assessment, let us take it correct, But how can he award the 40 rupees to one person for same category?
No, we just talk about the other, regarding the woods and the trees. In some case, the land is just 1 lakh and the amount of the bamboo and the woods comes to 88 lakhs. I think one of the decrees speaks like that. I don't know. Anyway, yes.
No, Your Lordship.
Yes, please continue.
Paragraph 6.
Yes.
In order to appreciate the controversy, we would like to refer section 18 and 19 of the Act, which are reproduced as under. I am not taking to Your Lordship section 18 and 19. We have already read.
Yes.
Then come to Your Lordship, last line. Under section 18 of the Act, the only requirement for the person interested who had not accepted the award was to move a written application to the collector, requiring that the matter be referred for the determination of the court. One of the grounds for not accepting the award was the amount of compensations. Once such application was moved, it was the duty of the collector to make a reference to the court under section 19 of the Act. While making the reference, the collector was required to state for the information of the court, the particulars as mentioned in clauses A to D of subsection 1 of section 19 of the Act. Thus, it was the duty of the collector to mention not only the situation and extent of land, but even particulars of any tree, building, or standing crops thereon. The agriculturist whose land is acquired may not be fully convergent with the khasra number area as entered in the revenue record and the Union of India, or the state acquiring such land should not be allowed to take any advantage of such ignorance of the agriculturist. Once an application is moved for taking a reference under Section 18 of the Act, it becomes the duty of the collector to send full information to the court regarding the entire land acquired, and it is thereafter the duty of the court to decide the matter in accordance. The base is the information provided by the collector under Section 19.
So
Then your lordship,
duty of the collector under Section 19.
19.
Yes, has to be discharged.
And if he has not done, then he has to come before the court and justify. That is what Calcutta Weekly has said it. Then your lordship, one more judgment possibly will...
Can you hold on? This one, will you?
1968, SCC online, Kerala, 92.
Yes.
92. Para 8 and 9.
Yes.
Para 8 and 9. In making the reference to court, Lordship,
Yes.
in making the reference to court, the collector completely ignored the provision of Section 19 of the Act. He made no statement furnishing the particulars required by subsection 1 of the section, objection having been taken to the amount of compensation and his award being what it was. It was most important that he should at least have stated the grounds on which he determined the compensation as required by clause D of subsection 4. Neither did he prepare and forward the schedule required by subsection 2. All he did was to send his record to the case with a covering letter called a reference letter, of which letter number so and so. As I pointed out in this case, what is the letter? The records of the LA case number on the file of this office are forwarded herewith under Section 18. The 16 cents of land so and so for the Koja research form. The amount awarded was paid to the defendant. A copy of the award statement number so showing the name of the defendant. So, Your Lordship, what the collector has done, he sent the file, entire file to the, as in this case, Section 18 file, Section 18 application is just sent. And after receiving the reference, Your Lordship, the court has to struggle very hard to get the measurement, demarcation, or after the land is demarcated, then only one came to know, landowner came to know that what thing is there in that land. Because it is a running land from the field. So after that, we have made an application to the court that that they should also specify the other things. Then it was mutually decided that it's a question of evidence. Both the side will lead the evidence on the remaining issue, on the other things, and accordingly the matter proceeded for evidence. We started bringing the evidence, and whatever we could bring it, we have bought it.
No, you're correct in that manner. The way it's been handled, it's a very
awfully bad.
Yes.
And
that's why it took how many 20 years?
22 years now, Your Lordship. 22 years. And one thing more, Your Lordship will appreciate. Whatever Your Lordship will give it. Now, that amount, what I get after 22 years, what was the value of that amount had I got in 22 years before?
Yes, of course.
Inflation is so high, Your Lordship, so high that even the 20 times will not compensate the claimant, Your Lordship. Money buys the money. No, the money which I ought to have got it, and which Your Lordship will fix it in this proceeding according to Lordship's experience of dealing with such lands. What will be the exact value 22 years before?
That we cannot go next side. Now we're going to go to correctness of the, and whether the appeal is sustainable. That's all. And of course, on a cross appeal. Yes.
Then
next point. Did you finish your point, section 1819?
Yes, section 1819 I have finished, but that interest, what was the order of the court? Number one. Or the relief. Your Lordship, volume 1, page 141. Volume 1.
Yes.
Last line, reliefs. The claimant is therefore found entitled with 30%.
Where are you being found? Para?
No, last one, page number 141, last
141.
line. 141.
After 131. Reliefs.
Relief.
Yes.
The claimant is therefore found entitled with 30% solatiums per annum. This was corrected because solatium is not per annum on enhanced compensation and with 12% interest per annum on the enhanced compensation. With, the 12% is awarded on the enhanced
Once again,
compensation.
just come again. The claimant is therefore found entitled to 30% solatium, okay?
On enhanced compensation.
But solatium should be in market value, correct?
No, on the entire compensation.
Okay, on entire compensation. Yes.
And with 12% interest per annum on the enhanced compensation, with effect from the taking over of the land till payment is made in court. And if the amount is not paid in court within 1 year, an additional interest at the rate of 15% per annum shall accrue to the said awarded amount till final payment by the collector.
Yes.
Now, this is the judgment, finding of the court. Now, here, one absurd thing is that about the rate of interest. Collector has also awarded 12%. Now, possibly, Your Lordship, the court has gone into the that once collector has awarded, she also has awarded 12%. Nevertheless, even if it is, as per law, it is 9%, this court, under its appellate jurisdiction, can
it exercise discretion when it is prescribed by law?
Your Lordship, no, here the collector has also awarded 12%. So the court has also given 12%. For the this is small period, 1 year. 1 year only. Beyond that, 15% there is no dispute. Now, let us see the decree. Page 327.
Page 327.
327.
Yeah, I think I'd seen that earlier. Yes. Decree.
It is.
Yes, I flagged it. Oh.
The claimant number 1 has already drawn the compensation awarded by the opposite party collector under protest on 19/8/2003. The said compensation included amount for the land measuring so-and-so at the rate of 18% plus solatium at the rate of 30% plus interest at the rate of 12% with effect from 13/9/2001 to 7/7/2003. This is what the collector has awarded. No dispute about that. That is 2,55,685. Then your lordship come to the next page. However, the court found that the claimant number 1 was entitled to be awarded an enhanced rate of 160 per square meter. Now, with the 160 rupees per square meter, the amount comes 3,36,960.
Yes.
Then your lordship, that the landowner was also found entitled for damage to hybrid tissue.
Yes, this one.
Tissue.
Exactly.
Tissue, cultured plantation, banana plantation.
If land was only 336 lakhs, now banana 6,72,000.
Yes, lordship. That is what the
another 4,48,000.
Yes, and these are
fencing 1 lakh, 1 lakh.
Lump sum rate
That
for
is what?
Tita Champa. All these things are covered under the word compensation. Compensation for damage to the fencing.
There's this question, yes. Because solution there is 30% enhanced
So,
of what?
total
that
enhanced
is on a total amount of 15,61,000 instead of market value.
This is the total compensation, total enhancement.
Exactly, total enhancement. And,
Yes.
And interest solution is given 30% on the entire amount. Not, it's been given entire
Yes,
amount.
on the entire amount. Entire amount, that is 15,61,000. Because so far solution for the initial amount is concerned, that is already taken care by the collector.
No, it's here. I'll just correct it.
No. There's some confusion.
No, well, so I'll just correct that. This is my understanding. Kindly come back to page 328.
Right.
So original amount which was granted is 2,55,685, which is by the collector. Now, if your lordship sees serial number 2 in page 328,
Yes.
this total area of claimant number 1 acquired by the opposite party. So the amount that is granted is 160 per square meter. This is the enhanced rate. So that brings the total to 3,36,960.
Should minus that first. That's
correct.
not a minus.
Yes, that was not deducted.
That was not subtracted from the initial amount that's only taken by the claimant.
Yes, so that would bring it to 81,275.
Yes.
Now, the next issue is...
No, lordship, this was deducted.
It was deducted after application of interest, which is wrong. It should have been deducted at the very early stage, before applying the interest.
How you can say
what
that?
happened was, okay, compensations awarded by the collector in
That it
section
should have
11.
been deducted at the initial stage.
2,55,000, correct? Now enhancements have been given the same 2,000 approximately square feet
No,
of meters, sorry.
on your lordship, 2,55,685, no enhancement is given.
No, that's not
but
what it is.
The reassessment was done around 2,106 square meters, the amount at 160 per square meter,
Yes.
it came to 3,36,000.
Yes, your lordship.
So, entire amount was factored in, interest was paid.
Yes,
then the amount
either-
was deducted.
yes. But why should that be? Interest is already
was
granted.
paid on an amount that had already been drawn by you.
Yes, exactly. And for that entire period. How could that be? Because
That
even
is
in
we
the...
detected last time.
Yes, on the original amount, interest is already paid, which my learned senior has already referred to.
We'll continue at 2 o'clock, Mr. Jindal.
Lordship, we have a meeting today, senior advocates. We'll continue. कल क्या position है?
The other matters will take up at 2 o'clock then, at 2:15. Other hearings. Yes.
Tomorrow we'll continue.
Tomorrow, I don't know whether it will be possible. Yes, sir.
I won't take more time.
Once even the cross appeals are there, that will take a very long time.
Mr. Jindal, you see that we cannot go by your gainsaying, because according to your mind, you're going to take much time, but but once you start the flow, you can't interrupt the flow also. But that's how the understanding of the court also comes easier when the advocate can marshal his points and arguments of flow. That's the matter 2:15. Why is Dr. Moskar looking worried?
Tomorrow we'll continue, Lordship.
Tomorrow possible?
Tomorrow then.
Yes.
Two matters were left. I requesting some other day.
Item 29 is also left. Item 29, granary, that Chester filled up.
No, two will take about. Why law is not agreeable to sit after to argue after 2:15?
Lost the habit.
Lordship may have it after 2 weeks or so, because this matter will require some time, my lord. My friend is here, Mr. Themis.
29.
Item 29.
29, I'm not there.
What's ready to sit?
Lordship, senior.
29, who's there?
Lordship, senior TT Dingdo is leading the matter.
Yes. He's ready with the matter. I saw him today.
Yes, sir. Earlier
He's
he was
still
there
here.
in the court. Lordship, I'm not aware of that.
Other matters we can take up 2:15. Any urgent matters?
24 and 31.
After 29, okay, after 2 weeks, yes. You are appearing on his behalf.
Lordship, on behalf of the state respondents.
MS so please for 2 weeks, yes.
Vice Lordship.
24.
Not 24.
Disability pension. Next week.
Mr. Pandey wants to do it today, right? Why? Yes, why is there a mental block to sit at the second half? Mr. Khera is looking worried that the matter will be taken up in second half. You'll take it up.
I think you're drawing it.
You're drawing the matter. Or we will take it up now. Yes, 24.
And 31.
Mr. Jindal is banging his head against the wall. Yes, this matter is not being taken up. After 1 week, 31.
Then for 27, I think he.
You want to withdraw it?
Lordship,
Why?
Lordship had asked us to take instruction. We will be filing an appeal under 7I. That is a remedy which was there.
But then the time lapse, how will you address it?
That is a prayer I stand with, Lordship. Since we were pursuing it here,
yes, sir.
We will undertake to file it within 2 weeks.
Where you unmuted? Someone being very violent. Unseen, yes.
Lordship, we'll undertake to file the appeal within a period of 2 weeks from today, and
and for the period spent in pursuing other remedy, will it be condoned?
Lordship, actually, in such cases, in Act, it is nothing is there. So the Limitation Act.
It's not applicable, yes. But MBC is reasonable time a person's come to court.
Yes, Lordship.
Then we'll pass orders. Yes. That you withdraw, seeking liberty to pursue alternate remedy. Yes, 27. Shall pass orders.
Lordship, under 7I, we'll file it to the
7I, right. Okay, yes.
Oblige.
Oblige.
Then this matter may be disposed of, Lordship.
Of course, we disposed of.
Lordship.
Yes.
Oblige.
Lordship, item 28. Again, a PF matter with my friend Ms. Bhattacharjee. I was praying if this matter could be taken on another date, my lord. We were otherwise ready.
Yes.
Lordship, yes, Lordship, but except Wednesday, Lordship. Any other day, except Wednesday, because Lordship, today also I had one evidence in Nongpo. I adjourned this matter for hearing in this case.
Then we'll hear at 2 o'clock, at 2:30.
Lordship, some difficulties, my lord, in the second half, my lord.
See, this court thought we'll reverse the process. So the lawyer, we have the motion at 2, and we do the hearings first from 10:30 to 1:15. So that way, lawyers be ready to do matters after 2. What do you say, Dr. I think it'll be a better proposition. The motions at 2:15 only.
Possibly, my lord. Possibly. But for today, my lord.
Right. After 1 week, 28. Okay. That's it.
Right.
Obliged.
Yes.
Lordship, item number 23, Your Lordship.
Number?
23.
Where's the petitioner? Mr. Nyota is here.
Yeah,
No objection.
After a week, Your Lordship.
1 week, okay.
All right.
Yes, and 26, you're interested in that matter. You file your affidavit?
Yes, Your Lordship, we have filed.
Okay, 2 weeks, yes. That's it. All over. Why, what's the harm? 1, 2 matters we can do. Good. Mr. General's matter is very interesting. It's really convoluted.